Thank you for joining us. I'm Nathan Walls with Surrey on the Go. Today I'm with Howard Jones and Marty Needham. Today our topic of conversation is quasi-judicial hearings in Surrey County government. Howard, if you'd like to start off our conversation.
Okay, I'm an attorney and I represent the Planning Board, the Board of Adjustment, and the Historic Preservation Commission, as well as Development Services. And Development Services is headed by its director, Marty Needham. Good morning, Marty.
Good morning, Howard.
Okay. Today we're going to talk about quasi-judicial hearings. Now, first thing you need to understand is these are not new. We've always had them in some shape or form, but the legislature in North Carolina has made some changes to the statutes, and the courts have also made some changes about how we have to do business. In addition, the county commissioners have made some changes to make these more transparent and better able to protect citizens' rights.
Howard, what type of quasi-judicial decisions does Surrey County have?
Well, you basically have four. One, from the Board of Adjustment, the first one is you have special use permits, you have variances, and then you have appeals from administrative decisions. And then the Historic Preservation Commission also hears applications for certificates of appropriateness in the Village of Rockford Historic District.
What are quasi-judicial hearings?
Well, let's just step back for a moment and understand that the Surrey County government can make three types of decisions. They can make legislative decisions, administrative decisions, and quasi-judicial systems. So it's one of the three types of decisions that county government can make.
How are these decisions different?
Well, we all know what legislative decisions are when we watch the news. In Surrey County, legislative decisions are made by the Board of County Commissioners. They're elected, they're government officials, and they're elected in order to decide policy. And those decisions are made in public hearings where the commissioners set the policy of what types of laws we're going to have and what expectations that citizens have of their government. They have a maximum amount of discretion in doing that. They can consider a variety of things, politics, beliefs, a whole host of things. And there is a maximum amount of public engagement. The public is invited to attend, and everyone can share whatever opinions they have about the legislative process. The next type of decision is an administrative decision. That is a fairly simple decision in that we have rules that are in our ordinances, and staff make those decisions by applying those rules to a simple set of facts. There's no discretion involved in that. It's just, does it qualify under the rules or does it not? In contrast to all that, we have quasi-judicial decisions. And a quasi-judicial decision is just what it sounds like. It's quasi or almost a judicial decision, a decision made by a court or by a judge. Now, we also have a public hearing for these in Surrey County. But these decisions are by appointed officials, not elected officials. We apply the standards that the Board of County Commissioners has already decided on. But we do two things differently. First of all, sometimes those facts are contested. So the Board of Adjustment or the Historic Preservation Commission, they have to decide disputed facts. The other major way in which it's different is that the standards with administrative decisions are very rigid and very simple. They're black and white. Did you meet your setback? But when you get to a quasi-judicial decision, the standards that we're applying are much looser. Is this project in harmony with the surrounding community? Is it congruent with the other buildings? Those standards are hard to apply and they have discretion. So we have to have a quasi-judicial hearing. And in that hearing, we only consider evidence from sworn witnesses. We have a court reporter that records the hearing. Everything is on the record, both the evidence and the deliberations of the board and their decision-making process. The last thing that's important to remember is these decisions are not based on politics or personal beliefs or personal preferences. They're based upon what the ordinances require and whether or not the facts have been established.
Who can represent the applicant in a quasi-judicial hearing?
Okay, and this also is a little bit different. You don't have to have a lawyer to represent you at a legislative hearing, nor do you have to do so if you go for an administrative decision. You are allowed to represent yourself in a quasi-judicial hearing. However, someone else can't represent you. Your surveyor can't represent you, your engineer can't represent you, your realtor can't represent you. The only other person that can represent you is a lawyer.
So, Howard, what types of evidence is the decision based on in a quasi-judicial hearing?
Yeah, well, the evidence must always be, and the decision must always be based upon evidence that is competent, material, and substantial.
Howard, what does competent mean?
Well, competent means reliable. And it's a little different than if we were actually in a superior court or district court, but we still want to make sure that the evidence is reliable that we're going to base our decision on. With documents, we're a little bit more relaxed with regard to what type of documents that can be let in to consideration at the hearing. But on the one hand, if you bring in a copy of something on a government website that's easily verifiable, we're probably going to accept that. But if you bring in an anonymous posting from Facebook, we're probably not going to consider that because we have no way of knowing if it's reliable. Now, there's also sworn testimony. Every witness has to take an oath, and there's two types of testimony that the witness can give. One is about facts, and everyone is competent to testify to facts if they have firsthand knowledge. But the hard thing for people to understand sometimes is that we often discuss opinions, and opinions can only be allowed in if the person has a basis for offering those. Usually it requires an expert. And the two prime examples of those are if we're going to be considering whether an application is going to have a substantial negative impact on a neighbor's property, the only person who can testify about the impact as to the future value of property is either, in North Carolina, is either a realtor or an appraiser. A homeowner can't do that. The other is if someone wants to offer evidence and contend that an application for a new type of business is going to create a traffic hazard, you're going to have a traffic engineer because those are expert opinions.
Howard, what does material mean?
Well, material means just what it says. It's relevant to proving a fact and issue. The facts and issue in a given case are going to be those that relate to the project, what's being requested by the applicant, and the requirements of the ordinances. Whether or not we like the applicant or whether or not someone has a dispute because of a family matter or something like that is not material. It's because it's not relevant to any facts that are an issue.
And what does substantial mean?
Okay, well, substantial is probably the most interesting of these terms because substantial means, on the one hand, it's enough evidence that whatever board we're talking about, for example, the Board of Adjustment, if there's enough evidence that they could determine a certain fact is true or that it's false. Now, in these quasi-judicial hearings, there's a scale or a seesaw, if you will. And the burden is normally on the applicant to bring forth enough evidence of all the elements of their case that they have complied, for example, that they have complied with the requirements of the ordinance, that there's not going to be a public health problem, that there's not a substantial negative impact on the adjoining property owners, and that it's in harmony with the rest of the community. Once they've brought forth just a little bit of evidence, okay, then that burden shifts to someone trying to fight the decision, the opponents of that decision. And if they put in evidence, then what happens is the board has to decide who's right.
Howard, what happens after a decision is made by the board?
Okay, well, first of all these decisions have to be reduced to writing, and they have to have adequate findings to support the decisions that the board has made. Once that decision has been rendered, if a person has gotten an approval, then they can go begin their project. If a person has been denied approval, or if there's a neighbor who thinks that the approval shouldn't have been given, then the parties can appeal. But it's important to remember you're always going to have a written document that sets forth the reasons that the board made that decision.
How can people learn more about the quasi-judicial decisions?
Well, they can learn more by looking at the Surrey County website, where we have our policies and procedures for the various boards listed. We also have on the Surrey County website a copy of the ordinances that are at issue. You can also look at the North Carolina general statutes, but I would encourage you to look more closely at the ordinances. They're a little bit easier to get through. You can also do what the first thing I do when I have a new question. I Google North Carolina School of Government, and then I'll put in the topic. And believe it or not, I don't even have to spell out School of Government. NCSOG rezoning. And what's going to pop up are all the articles and the blogs that the professors at the North Carolina School of Government have written on this. It is a great starting place. And most of these have been updated within the last 2 to 3 years so that they are current. It is a great starting place. The other way you could learn about this is you could hire a lawyer. Or one of the best ways is, and probably more enjoyable than any of that, is to call Development Services and speak to Marty.
So Howard, what is your role in the quasi-judicial hearings?
Okay, well, the role has evolved. My first role was to provide training with regard to the law and what's required under the North Carolina general statutes to the board members, and go through a step-by-step process during the hearings so that they could understand what the legal requirements are. And we've done that for a while now, and the board members, they have learned a lot. So that training is basically over now. What I'm there for now is to, number one, to help the board if there's evidentiary questions, and they're allowed to ask for advice just like a judge is allowed to call the administrative office of the courts and ask for advice on a question that's novel or they haven't encountered before. Also, to help the board, I'll be sitting there with my laptop, and once they have reached a consensus and decided they're going to rule a certain way, they'll have to make findings. So I'm there to make sure they get those findings down in the manner that's required by law. But the lawyer doesn't help the board make a decision. Those decisions are solely up to the board members and are solely based on the facts that are of record. And all those deliberations are in public. We don't take breaks and discuss things. That is strictly forbidden under the open meetings law. Every single consideration of the board is in public.
So in more or less words, you're making sure the quasi-judicial hearings are ran properly.
Yes.
And what is the role of the court reporter in those quasi-judicial hearings?
Okay, well, it's really, there is the obvious role that the court reporter is there to make sure we have an accurate record. All of our meetings, from start to finish for the various boards, are transcribed by a court reporter. Those are then become the official minutes and are adopted at the subsequent meeting by the board. So there's not really any room for argument about whether or not we recorded something or whether or not we remembered it right when we wrote the minutes. The other reason the court reporter is there is that every now and then we have an appeal. And if a hearing is, usually a hearing will last anywhere from 30 minutes to an hour and a half. Sometimes these hearings will go on for 4.5, 5 hours. And for us to transcribe 5 hours of discussions will shut down development services. And we won't be there to do anything else. So, and it's just very helpful.
What is Ed Waltz's role as county attorney when cases are forwarded from these boards, from quasi-judicial hearings to the Board of County Commissioners meetings?
Okay, well, first of all, Ed is the county attorney, and he has decades of experience on how government runs and how it has to run. So he is a broad spectrum attorney for the county. My knowledge base with regard to county proceedings is more limited to land use and the different decisions that are made by those three boards. Quasi-judicial proceedings are not any longer appealed to the Board of County Commissioners. Those decisions will go on to Superior Court. Okay. Where Ed will get involved on legislative decisions if there is a general straight-up rezoning or a conditional rezoning. The planning board is required by law to make a recommendation to the county commissioners. That recommendation then goes to the county commissioners, which they can follow or not follow in their discretion. That hearing, okay, is run by Ed Waltz as far as the legal requirements. So Ed also acts as a general mentor over the entire process. So if there are policy decisions and if there are matters that need to be considered by the county commissioners with regard to the different departments, Ed will advise the county commissioners.
What are the benefits of these quasi-judicial hearings to citizens, the Development Services Department and Marty Needham, and Surrey County government?
Okay, well, number one, for the government, it accomplishes transparency and it allows these decisions to be made consistently. You mentioned Ed, one of his favorite words is consistency. And if you think about it, that's half the role of government, to treat everyone the same. So our big push is transparency and consistency. Now, the benefits to the citizens are that they know when they come in what the rules are. We didn't make the rules up yesterday, and the rule is the same for everyone. We don't call favorites. Evidence, the rules of evidence are the same from everyone. The right to an appeal and a decision is the same for everyone. You're going to get a fair decision that you may agree with, you may disagree with, but what you will know is that it was done the same for everyone. So first of all, the citizen knows that they're going to be treated the same. The second benefit is for developers and people actually who want to engage in business. They know that the rules are set out in the ordinance and our policies and procedures are on the website. They know that they can come in and put on evidence, and it doesn't matter if citizens like or dislike what they're trying to accomplish. If they have complied with the law, then they're going to get a development approval. And that's the way it should be.
Right. Is there anything else that you gentlemen would like to add?
There's no real magic here. And I would encourage members of the public to, number one, keep watching Surrey on the Go, but number two, come to these meetings. They're free. Everyone's allowed to attend. And you're allowed to make public comments when we have time on our agenda. So it's good to learn about your government because you pay for it, and it is your government. Okay, well, the takeaway is that Surrey County makes every effort to follow the rules and that the rules are the same for everyone. This process is intended to give a fair shot and a fair shake and a fair decision to the person requesting a development approval And sometimes there are people who are opposing that development approval. So have confidence. It can seem overwhelming, but don't be afraid to ask for development approval because it requires a special use permit, or to get a certificate of appropriateness, or to ask for a variance. Just call up Development Services, ask them to walk you through the process, be prepared to put on evidence, and you'll be treated the same as everyone else.
Marty, anything you'd like to add?
To expand on Howard a little bit, if you're thinking of developing property in the county, rezoning, something like that, you have questions, feel free to call our department. We'll be glad to help you walk through the system. It is daunting. It sometimes can take a while, but we're here to help you, so don't hesitate to call if you have any questions.
Howard, Marty, thank you so much for your time today. To all the viewers at home, we hope this information has been extremely helpful. Again, if you have any questions, call the Surry County Development Services Department. Thanks for watching.